Okay, and good evening, everyone. Welcome to the Thursday evening seminar. Tonight is the latest in the Adjudication Matters series presented by Mohammed Haque, and he will be talking about defending a claim. So without any further ado, just to remind you that if you have any questions for Mohammed, he's happy to answer those. You can either pop them onto the Q&A or chat tool in the bottom toolbar there, or if it's something you don't wish to raise in an open forum, Mohammed is always happy to have an email from you. You can see his contact details there, mohammedhaque@silverllp.com. Okay, Mohammed, off you go.
All right. Thanks, Julie, and welcome to all our attendees this afternoon. I was just telling Julie that it's really harsh on people to ask them to attend a seminar on something like adjudication matters, defending a claim, when the pubs are open, the weather is wonderful, and we have not been going out for a while, so it's a great opportunity, and we don't know when there'll be again a third round of restrictions on us for COVID. But anyway, I mean, it seems that at least 20 odd people up till now hasn't got anything better to do, or love adjudication so much that they felt, you know what, I'm going to go and attend this, not going to listen to the records only. Now, today's is defending an adjudication. Those of you are or have been attending, you know that I'm running this series and I'll be running it up to the end of the year. And I will very shortly start another series called Changes in Construction Contract, and I'll run at least 12 webinars on that as well. But for the time being, I've been running it since early, I think January or February. And if you have missed or didn't attend any, and you think you want to have some or give it a go, the recordings are pretty much available over the internet. So you can go back and watch them and see how it developed. Now, off and on, of course, I've discussed so far about defending an adjudication, and also even discussed a little bit about how to draft a response and things like that. But I felt it is a better idea to have a whole evening dedicated to looking at adjudication from the defense perspective. Now, the first slide, I'm not going to concentrate a lot on this, but certain things needs to be reminded that whilst the claimant, called as the referring party in adjudication, has the world of time actually to prepare for the adjudication and frame its claim in a crystal clear way, taking all sorts of different expert witnesses and reports and things to be absolutely sure that they're going to win it. The party defending the first challenge is that they do not have much time in their hand. Now, although possibly the parties do discuss the dispute for a while before they go to the adjudication stage. Sometimes it's discussed months and years ago, and then all of a sudden, when they've completely forgotten it, the project is completed, and the claiming party, the referring party, looks into it and says, you know what, I've got a claim there. I'll not that this dispute has been crystallized, or no formal crystallization is required because it's only a payment dispute. So I'm going to go for it. So before receiving the notice, unless every single employer and the contractor and the subcontractors have a system in place where they record their possible disputes, it could be that you might be hit by a notice of intention to adjudicate just out of the blue. And it so happens where the companies change their officials, you know, the people who are handling a contract or a project, if they leave the company and someone who's succeeded by or taking on from the earlier and is not apprised that there are issues, the chances are more. And why am I spending so much time on this little thing? Because due to COVID, what we see is we are coming out of COVID, and claims are getting more and more popular, or something which is getting a regular feature for the companies for the time being. Insolvencies are rising, so for various reasons, shortage of things and other things, and your cash flow is in difficulty, and at the same time you now need to pay more because the restrictions and the incentives and the payment halts are now all gone or going to go away. So people are kind of searching for claims. So this is a time where you better reapprise yourself, reassess your position, think thoroughly that if you have any claim or a possible hit by another party to the contract. So that's something I would say before ever receiving the notice, take some kind of preparation and assess your position and see and try to kind of contemplate what's or foresee what's coming. Now that's before receiving the notice. Now, once you receive the notice, assuming that the scheme applies, you only have 7 days time for the referral to come. And quite often that not, the referring party doesn't wait for 7 days, because what actually happens, they send the notice of intention, by the way, by the word notice, I'm saying the notice of intention to adjudicate. That's the formal thing, but I'll call it as a notice. So before issuing the notice ever, what they do is they prepare the referral, they prepare their bundles, the evidence, the annexures and everything. They just are completely ready to push the button when the time comes, and they send the notice, which is a kind of a synopsis of the referral, and then on the same day or at the most the next day, they send it to the adjudication nominating body to get an adjudicator, and depending on how busy the nominating body is or who that nominating body is, they have 5 days time, but they do not need 5 days. Within a day or two, normally they nominate one. And as soon as an adjudicator is nominated, the adjudicators are all ready with their letter number 1 to the parties, which includes normally the terms and conditions and the information that he has already been nominated. A standard letter is always ready. We just change the reference, the date and the name of the parties, and just send it in a tick. Sometimes our secretaries do that anyway. So so it could very well be on the 3rd day from the day of, or the 4th at the most, you see the nomination process, the sort of appointment process is complete. And as soon as the referring party receives the first letter from the adjudicator, what they do, they just electronically serve the referral. And the rule is under paragraph 7 of the scheme, there's been an interpretation of it, that what is meant by giving the referral. Giving the referral doesn't mean that all the attachments should also be served at the same time. Even if electronical service for the attachments are not permitted or been asked to be served simultaneously or a day after, it's sufficient that the referring party sends a copy of the referral document or referral notice, to call it properly under this scheme, electronically. And in these days, that's sufficient submission. Nowadays, I have experienced that, well, due to technical problem of IT, sometimes what happens that you are not allowed to download documents from third-party servers. So immediately the responding party come back and say that we couldn't download it. So, and off late, I've experienced that to kind of put the entire referral on the body of the email and sending it like a 20-page long email. and sending that this is the notice, this is the referral notice. So the service is done as soon as that's done, and that's the completion. Got 7 days from the date of notice, the referring party, up to the next 7 days to complete issuing the referral, but it might come in 5 days' time. And then normally the adjudicator, this is the completion of the appointment, and normally the adjudicator will issue his letter number 2, allowing the responding party, normally I'm saying the 2 sentences below, I'll come back to it in a second. Normally the adjudicator will invite the responding party to submit any response if it wishes to the referral. Now, that's where the whole adjudication process starts. It's only a 28 days process. So more or less, even from the date of the notice, the defending party or the responding party, as it is called in adjudication, will have about roundabout minimum 10 to 13, 14 days to prepare the response and submit it. And given the fact that an adjudication is for one dispute only, and given the fact that the adjudication, the party representatives and the adjudicators all are experts in construction in one way or the other, and most of them are like me, dual qualified. As such, if you go to experts, it's quite a lot of time. I mean, as a party rep, I've heard many a times parties moaning that this is this, that is that. Well, I mean, ambush during or over the Christmas is a possibility, but adjudicators look at it slightly differently nowadays, and they do accommodate and create the timetable in a way that you still get the benefit of that much time. But mind you that adjudication is something, a quick process. So if you think, oh, I'll still enjoy my weekends, no, for the time being, that's gone. Now, the procedure to be followed is very important because you got to first understand that whether this scheme applies or not, because there are subtle differences between processes which are pretty contractual, or other A and B has developed it under the scheme, and some of them could be low value ones and things like that. They do have differences. That's one aspect of it. And the other aspect of it is the internal process, so to say, between the day 0 to day 28 or plus 1442 plus 5 days for the slip rule. So it's either 28 plus 5 is 32, or 42 plus 5 is 47 days. Within this time period, how the adjudication process will run is primarily in the hand of the adjudicator. So he's the sole arbitrator to decide how he's going to pan it out. And unless he's giving too little a time to one party and then too much to the other, the argument of natural justice will not win. So you may dislike it, but you have no other choice but to follow, because it says in the scheme that you got to follow the instructions of adjudicators. So that's how you got to get a fair, clear idea that what's coming up. That's the first thing you got to think of if it's defending a claim. And the similar thing applies if some of you are just a party representative. It's a similar thing. If somebody comes to you and says that after the receipt of the notice, that what it is and how do I do, and the best thing is to remind them at the outset that the journey for these many days are going to be very tough. You have to work day and night to compile, unless you have organized it months and years ago, anticipating. It's going to be very, very quick a thing, and you got to be very careful and be cautious. So that's something it applies for everybody. We should all remind ourselves that we are in that position. And as such, what kind of procedures are coming in place is also a very important thing to think of and take a note of. Now, we should start by doing a caveat first, that under the scheme, the responding party do not have an automatic right to issue a response or a defense. This is something I've found people who are representing parties for years, they either do not know or they study it at their schools and they forget it totally. So don't assume that this is like an abusive process if this has not been something you want 5 days, 7 days, and that's not been granted so easily. Don't just assume that, because the starting point for, if you challenge that thing in the TCC, the starting point for the judge to look at is, wait, you do not have a right to respond or produce a defense. Now, very interestingly, the next sentence, which is also binding law, that the responding party can submit any defense and the adjudicator is bound to consider them. And it's been reconfirmed as late as early 2021 that an adjudicator, if he or she excludes a defense from considering it, that's a breach of natural justice and the decision will become unenforceable. At the beginning, you might say, these two are contradictory. No, these two are not. The defense or the responding party doesn't have as of right a right to go and submit a response, but if it chooses to do so, then the adjudicator's hands are tied. He or she has to consider it, no matter how unrealistic the defense is, unrelated defense is. It may contain a counterclaim, it may contain a set off from some other debts, but the adjudicator cannot say that I'll not consider it, you don't have a right under the scheme to present it. So it's absolutely your choice, meaning the responding party's choice to decide whether to throw something on or not. Now, having said these contradictory things, it's the ground reality is, because the adjudicator needs to be neutral, that's under the scheme and the Act, and because the adjudicator's office is a quasi-judicial office, meaning that he is taking a decision over the citizens' rights. So ex parte Electricity Commissioner's case, famous speech and decision from Lord Diplock of the House of Lords, as it then was, now it's the UK Supreme Court, that whenever somebody is deciding on the fate of deciding the fate of citizens' right, they got a natural duty to follow natural justice. And natural justice doesn't mean something what you love or think as justice. Natural justice, one of the legs is that you got to give a fair hearing to the parties, audio alter partem, and that's been translated into, of course, legitimate expectations and fairness as well. So to avoid the breach of natural justice and to maintain the neutrality has been canvassed into the Act as well as the scheme, inevitably the adjudicator will give you an opportunity to respond. And as I say, it'll be between 7 to, I mean, I have represented parties in adjudication between 2012 and 2018 on a daily basis. So it's hundreds of cases I've represented. And all I'm trying to tell you is here that there's no point starting with a mindset that I will annoy and I will try to avoid. You're never going to win that way. So be prepared to ready to defend. It's although it's interim, but in most cases it becomes final through the back door. I will be having a full session on that later during the year. So don't take it like casually and think that, well, I can get away with it without responding to it. So let's go to the next slide. Obviously, I've been this thing. Have you done an objective evaluation? Has been a part of almost all my episodes and all my webinars since the beginning of this year. That please do not have a subjective evaluation. Okay, that, well, you know what, Mike doesn't like me. This QS, he's the problem. You know, that project manager, ever since he has come, life has become difficult. These are subjective evaluation of a dispute. I sometimes call them, I call myself as a conflict avoidance advocate or a resolution practitioners. And there I started talking about attitudes about dispute a long time ago, and it's getting more and more popular. So some of you, if you are there the other day, the greats like Mark Enthisser also is nowadays acknowledging that the attitude matters. And the attitude matters to, from my end, is not to have a quarrel model attitude in resolution. It's not an adversarial process. Yes, you have the right to express your rights, but if you take an objective evaluation rather than a subjective evaluation, you'll be better off. You'll stand a better chance, and you'll actually be able to see through the problem. Okay. Now, from a defense perspective, the first thing to look at is the claim legally valid? Meaning that, first thing, meaning that, is this under the construction contract that I have with the other party? Or are they claiming or making a tortious claim, for example? If it's a tortious claim, it's not a construction adjudication under the act or the scheme. So rather than thinking that, okay, you know what, this project manager is a bad guy, the architect was horrendous and this and that, or this contractor is impossible to live with, look at your contract. Look at your contract and see how the claim binds or flows either or not from the contract. And obviously there is always a chance that the claim is barred by time. And you know that I'm talking about, if you're not familiar with, I'm talking about limitation periods. And you know that limitation is not something that that precludes jurisdiction. Limitation is a defense. If it's pleaded, then the adjudicator cannot proceed further. So it's not an inherent jurisdictional issue. Even though a time-barred claim, a claim is time-barred, still the claim can be made. And if the responding party does not say anything, that means there's a live claim. He has or she has succumbed to the jurisdiction and waived the right of of limitation he has under it. If I set another example, it will become easier for you to understand. If the adjudication is under the scheme, and if the referral notice is served on the 8th day after the notice of intention to adjudicate is served, no one can succumb to the jurisdiction under the scheme. No, the only possibility is, in that case, if the parties agree in an ad hoc manner that, okay, that's not a scheme-based off-right adjudication anymore, but we agree that we will still allow the adjudicator to decide. And then if expressly stated that we will allow him to use the scheme and the powers of the scheme, so under that new contract, ad hoc basis entered into after the referral is submitted, or given is the proper word of the scheme, the jurisdiction arises out of that. So it's unlike limitation. There are issues which cannot be rectified just by tacit submission that, oh, you didn't say so. But there are issues like limitation. So you've got to think of if the claim is barred by limitation and if the claim is under the contract or not. I will come back to the question of under the contract more later on, but limitation, that's all. Is the other side capable of paying? Now, what I mean by this is, um, if you consider that this is a fair call, I am responsible under the contract to pay the amount of money or damages, or whatever it is, the liquidated or unliquidated, to the referring party. Even then, you may have a claim, a counterclaim, or even a set off, a debt which you can set off from this adjudication. So if you assess the financial ability of the other side, that's a very important thing at this stage, because if you think that the other side is just on the verge of becoming insolvent, it could be a better idea to accede to this and concede this jurisdiction, even though you have doubts, and bring your other claims and making it worth of fighting out and get everything under one bag. Because the beauty of an adjudication is, if you once win, it's virtually certain that the TCC is going to enforce it. They refuse to enforce very rarely. So the ability to pay and your other claims, even though not directly under the same contract, can be brought in by way of defense. So that's enormous potential which parties miss. Because, for example, I am claiming the value of a variation. You can turn around and say that, look, this is the best chance to value the entire variation account. And it may be so that up to that point, the whole variation account was not being claimed properly, and you get a decision up to that point that these are the evidence and this is what they have claimed for. And then the referring party will have shorter time to respond to you. I've experienced this as an adjudicator and as a defending party so many times that then they start going back. Then they take a step back that, wait, you are bringing in this, that, the other, but the adjudicators are very clear on that. Series of cases, I'm not going to bother you with that. Series of cases are there. What is in the name of a case? The rule is the adjudicator is bound to consider a valid defense. I mean, any defense, then he can decide if it's a valid defense, if it's materiality or not, but he's got to consider it. So that thing is vital to assess the ability of the other side. And more, if it's more likely that the party's sort of financial ability is going down, it's better for the defending party to step in and do as much as possible and make it an opportunity under one umbrella to get as much as possible as well. Then, of course, your fund to pay the non-recoverable costs. Because, see, you are not entitled, normally speaking, under 108, there is an exceptional kind of provision provided that you can agree, but that cannot be 100% because of the tolerance case, which mischief has allowed 108 to come into operation. So I'm all assuming a little bit of knowledge and background from you about the cost. So the adjudicator's cost, he has the right under the scheme and the act to recover it from the parties. And normally cost follows the event, meaning that although that's not a legal requirement, but if you lose, you carry the burden of the adjudicator's fees and expenses. And then on top, you've got your own fees and expenses. Please do calculate that. I mean, your representative might not be so open and explain to you that this much is going to be needed, and if you lose everything. I mean, I experienced last year and a similar thing, and I'm just sharing as a party representative last year. Somebody came to me, the claim was very, very, I would say, well, 50-50 type of claim. And we said, we've given our opinion that their chances are very low. And the guy insisted, no, you go on. And in our good assessment, we thought, a couple of people looked at it and said, there is no way you can get more than 45,000. But anyway, you know that the claims are made in an inflated way. So there were claims which were not so strong, but we added it into the bag and we claimed about 120K altogether. Now, the other side is very good professionals they were representing. And they also had a look, and they upfront on the table say, look, 45K, you want to close the deal? We'll just close it right now. No, I want to go up. So they went up to 55. And then they went up to 60. And then they said, look, if you want 65, we'll give you, but we need 6 months time then. No, our client will not agree. His mind got flushed. He said, look, I told you it's a very good claim. We'll go ahead and we'll win it and this, that, the other. Fortunately, that I have given them the caveat that if there is a chance, as you have said earlier, and you're going to lose, and then once you lose, these are technical legal issues, you may not get anything. And exactly that happened. And he bore the burden of paying us, he bore the burden of paying the adjudicator. And this great client then went to, without knowing, a friend of mine, a barrister, to sue me in negligence. And that friend of mine disclosed to him that I'm a friend to Mo, so I will not take the brief, but I can send you to someone else. And that someone else has had a tripartite meeting. And the first meeting, the counsel asked me that, how on earth, you being a adjudicator, the president's panel, you didn't remind him of this? I said, look, this is the first email, this is the last email. In between, this thing happened. He had a very good settlement offer, which I achieved, and he didn't care about it. And then that counsel said, I'm truly independently saying that I don't see any merit in that negligence. Why I'm sharing this with you, that if you are a professional, do cover your own back and don't just draw the rosy picture that these clients, even if they lose, they will pay your fees and they will not mind. They might. Most of the time they don't, but do send this and do send it in writing and ensure that the client has understood it, that the non-recoverable cost of the consequence of losing the adjudication. And once you know that you have covered that back, you are done. Otherwise, I've seen many times people sending letters to SRA, Bar Council, and whatnot. So that's something, please think it through. It's important both for the party representative and for the client. Now, the mental preparation, this is another nonsense. I mean, I'm sorry to say this, I'm sure clients are here, no offense to any client, but to share the experience of a friend of mine, we were called to the bar. I mean, he was called to the bar in early 1996. I was in 1997, but we were friends from university days. Now, he was in the profession, and I asked him that, how much are you enjoying it? So, how much am I enjoying it? At 9 o'clock in the evening, those days, the senior came to me and said, I got an argument to present tomorrow in the court, and this is the thing. So you make a proper skeleton, and I'll discuss it with you tomorrow morning. So that's the normal sort of you can expect for a pupil, at least those days. I don't work in chambers anymore, so I don't know. And then he said, then I was working, and I was so tired that around 1 o'clock in the morning, I went to bed. And a client called and he said, no, I've got this problem and they have issued a notice or whatever. And he said, look, I'm sleeping now. And he said, you're a barrister, young barrister, never sleeps at 1 o'clock in the morning. Fair enough. I mean, he said, then he got another call from somebody at 6 o'clock in the morning and saying that I've got this problem and you're the one who's the dealing lawyer in the chambers. So I thought I'd discuss it with you because I'll get busy by 8 o'clock in the morning. And then the senior came back around 6:30, 7 o'clock there. Where is my argument? Skeleton argument. So that's how a professional run in their normal life. And if you then just start phoning them back on every occasion, and then why the color, you don't like the color of the shirt of the architect, or he's a communist or a capitalist and you are the opposite, that's not going to help you. Because, again, I'm telling you, take an objective evaluation, not a subjective, that this is a bad contractor, this is a bad employer, and try to listen to your appointed experts. And if it is something that, okay, I have got not much to get out of it, just forget it and try to settle. It's not something that you continued for the sake of it. You never go anywhere in that process. There isn't any magic, at least in construction claims, that someone can, by an extraordinary advocacy or something, can win and other will lose. No, if there is a claim, 9 out of 10 times, the competent professionals running this show for a while will win it. If there isn't one, no matter how good the professional is, they won't be able to win it. So if needed, go take one opinion and then ask someone else to look at it. But do not just get excited that I have the physical and mental and financial ability to fight it. Many a times after 3 weeks, you'll find that your excitement is all gone. The next point, someone already asked me, and I will touch it upon in another slide later on, the sufficiency of evidence, because you may have a perfectly logical claim under the contract or a defense, but you may not have sufficient evidence to prove your defense. And if that is the case, it becomes difficult. And what evidences are there to prove is something I will touch on the later slide, so I will just finish on this point now. And do you have enough human resources to support the representative? Because that's another thing. If you're an individual client, you're all on yourself. Your wife, your kids, other people, won't be able to be with you all the time. If you're a company, then you've got other business to do, other contracts to perform. So do you have this extra logistics? I mean, just the other month, I was making a claim of loss and expense of 3.5 million. And I asked my client, would you please send me the such and such documents? And he said, I've sent your firm these documents already, so you can just find them out. And I said, when did you send it? He said, I sent it back in January 2017. And I said, look, I used to work in silver law. It used to be Silver Shemmings then. I left in 2018. I've come back in 2019. Now, if that's for me, the name you're telling, he left in 2019. How on earth I would know where he has left it, and we have changed our office as well. So, your representative may ask for documents which you have no clue where you have left it. And most of the time, people do not spend money on keeping records and managing the contemporaneous records and recording everything on a daily basis. And that's where it becomes very difficult. And that's another thing that mostly you will experience, that if you are a professional, that your client will always forget the most important document to preserve. And they will have the documents in their hand, which has got no relevance with the particular claim. So that's another thing, that logistically, are you in a position? Please do assess that. And the final thing, do you need an expert? Do not just go to an expert just because you think you need an expert. It costs money, and it's sometimes more or easier for a situation for you to explain than an expert, because he was not there at the time it happened. I'm not saying you shouldn't go to expert. You should always go to an expert when an expert is needed, but take your time to make a decision. I've seen, as an adjudicator myself, as a representative, many a times that the experts' money are simply wasted. And you will have high court decisions. TCC reminded that even of experts' behavior as well, that what expertism was he showing? So these are preliminary concern. We come to the next point, that you ticked all the boxes, you carry on, you want to defend, the first thing you do is a jurisdictional challenge. Now, minutes ago, I said, do not take a quarrel model, please accede and proceed if you need to. That's your internal decision. But tactically, if not for anything else, you may gain a little bit time by raising a jurisdictional challenge, which of course needs to be a valid one. No one should look stupid in front of an adjudicator, but they do frequently by raising extraordinarily technical issues in adjudication as a jurisdictional point, which has no chance to succeed. It's something like I found it even in my colleagues that are natural, even my friends who are adjudicators, seniors who are adjudicators, they sometimes feel irritated that if there is a nonsensical jurisdictional challenge not there. Of course, that's not the case for everybody. There are many, many people who just do not. My mentors, for example, I had more than one, and the senior most one once told me that this is a non-binding view anyway. So why bother to spend much time? Why bother to spend much time? And these people are thinking that they're going to make a meal out of it, which is not possible. So just sort of take a look, and I've just pointed out that normal grounds, I'm not going to discuss it in any great detail because I think my next webinar is on jurisdictional challenge and natural justice in adjudication. So I'll bring them in, but I just bullet point mentioning here that if you can confidently say that your contract says that there is a process to follow, for example, there are two named adjudicator, and only if they say no, then you'll go to the a particular A and B. Then if those two has not yet refused it, even though in ignorance A and B has appointed or nominated an adjudicator, the adjudicator would love to go away as soon as you do it, point out. So what you gain an extra time, extra week. Similarly, if the contract says that you can go to only go to REBA, and the referring party went to RICS, yes, just point it out. In a second's time, you'll see that the adjudicator will say, sorry, I'm not there. Wrong contract. Well, even this afternoon, I was reading the Scottish case, a blog written by Tony Bingham. If you're in the industry, you know how senior he is. That again, one more attempt and one more failure. So unless you're very sure that, well, parties have entered into a contract and now they have two contracts, and they brought in the dispute under contract number 2, whereas this was contract number 1 under which it arose, chances are the adjudicator will not pay much heed to your arguments that I have seen. I was personally involved as a party representative. The decision was challenged. One of the leading sects represented themselves, the party, into the TCC and lost badly when they argued that an oral contract, which was, my argument was varied, and they said, no, those were different contracts. And Stuart Smith, J, who's in the Court of Appeal nowadays, delivered the leading judgment, or the only, I mean, he was the only man who still delivered the judgment. So he delivered the judgment clearly stating that, look, well, of course, he didn't term it that, but clearly the spirit of the thing was, the argument from the council was simply nonsense. You know, I would take it as variation, not as a separate contract. So something very difficult to establish, but of course, in clear cases, you can go ahead. And as I said, I will discuss these things in a different webinar next month, Wrong party, yes. Again, as soon as you can point out that the contracting parties were different from the party who has brought in the adjudication, it will work like magic. The adjudicator, even in arbitration, I've seen the same as a counsel. They just simply go away. They just simply say, I'm sorry, I won't continue anymore because you are not the right party. Because what happens if they continue and then they lose, or they give a decision or an award that goes into enforcement, the enforcement is not done, they lose their right to get the money. So why would they put their efforts on where they have a chance not to earn their money, which is hard work, you know? Same or substantially the same dispute, again, in reality, very difficult to win an argument. Dispute didn't crystallize. Well, Lord, Lord Justice Colson in 2020 somewhere extrajudicially said that when a dispute has not crystallized for the purposes of adjudication in the UK, his answer was never. So you can imagine that it's highly unlikely that Amex guidance, post-Amex guidance, that a dispute has not been discussed by the parties up to a length, and there aren't sufficient evidence that there is a denial. Okay, I've also seen, well, again, as a routine, if you want to gain some time, you submit it as a party representative. I did that as well in the past. And what I've seen from senior adjudicators that, well, after a while, they come to know you as well. So they used to say more, I mean, I'm not going to give you, I can see you are looking for some time. I will give you extra 2 days. So it used to be in private discussion, used to be like that, you know, occasionally. But yeah, I mean, it's an unnecessary thing to pursue. Conflicts, another very good and important thing. If you really have a conflict with an adjudicator, and the nominating bodies are getting more and more serious about them, chances are the adjudicator might say that, well, I'm not going to continue because I'm sufficiently connected with one of the parties. Now, but don't try to play smart, because if you do have a conflict, which is a conflict in law, do raise it, but don't be playing over smart or trying to create. I just had an adjudication last month. I volunteered that the referring party representative has 3 employees. One of them is a good friend of mine, and 2 of them I have occasionally met or discussed things, but not in last 2 years. And the particular person who was representing is from a different office, but he thought a natural justice argument or a conflict argument with natural justice will be a very nice thing for me because I've mentioned it myself. And he kept on throwing new issues on natural justice, which is a nonsense. I mean, there isn't anything. I don't have a love for natural justice. I just am doing my duty as an adjudicator to let the parties know that this is the situation. So to the next slide. Now, the actual response, okay? Now, my humble request to all of you that you're listening, or the people who you will come with, please, before you put in your draft the response, first, in one sentence, be able to say, you should put it into writing what your defense is. What do you think the referring party did wrong that doesn't entitle him to get the remedy he or she sought? Now, somehow, till I started getting training as an adjudicator, somehow, and this is one of the reasons I'm running this, and I'm actively trying to push. Actually, last year, Congress, CIR, given me a resolution that this course will be developed as a course for the party representatives. I have been advocating for this, that unless you know how the adjudicator looks at it, it's difficult for you either to present a claim or a defense. Now, I know with experience you learn it, but there is no better way to have it set first, that how do I defend it? Now, the question as I posed, what is your defense? I will get back to it slightly later, but first thing to remember that adjudicator jumps to the redress sort, okay, and in your notice, not into your referral, okay. So you are asking for a money, you are asking for a declaration, you're asking for interest, you're asking for this, that, or not. Then what happens is A, B, C, D, he separates these redresses. And then underneath each, he finds out, is it the same contract we are talking about? Is there an express or implied term he's pleading? If so, is he pleading for a right as coming out of or granted by the particular term he's pleading? And then, if so, had all the requirements of that clause been fulfilled or connected requirements have been fulfilled? If so, what is the amount, the quantum? Okay, this is a legal quest. And then for each of these, has sufficiently consistent evidence been presented to me to consider that I tick the box for this? This is how an adjudicator take a decision. And you got to think on a similar line. Go to the redress sort, find out the grounds, see if it's coming from a contract, the legal ground, meaning the terms of the contract. Look at that. Is it the same contract you think the contract is? And is it written there that if a change is made of the quality or the quantity, if a modification is made, that's a variation. And if it's a variation, it needs evaluation. There's no answer to go back and say, oh, although it could be a quality change, but I'll not value it. Up till now, they didn't give me sufficient evidence. So what? It'll be valued. That means you didn't agree a value. It'll be valued in the market rule if it's a JCT contract. And the market rule, the first principle is the adjudicator will go and find out if there is similar rate within the contract. That'll be applicable. End of. You spend 9 pages on it, that there wasn't many sufficient evidence given to me. That is why within 3 days of submitting the application, I had to issue a payment notice. I didn't value it. No way, you're not going to win it. So please divide it like that and take step by step. I try to do it here as well, that are you thinking that you have a defense in law? Meaning that there is a clause within your contract, which is in the priority of clauses, overriding than other clauses of similar nature or within the contract, gives you a right which says that the other party is not entitled, or sets a requirement from which you can say that the other side is not entitled. Let's take a simple example. You're in JCT and the application for extension of time has not been preceded by a notice of delay. And I've seen many a times the architects are saying, oh, okay, there was no notice, so I'm not going to give it. Forgetting it, the fact that if the delay is within their knowledge, then they have a corresponding obligation to look at the issue as well. So in one way or the other, by accidentally, by site visit, if you come across a delaying event is happening, then architect also has a responsibility to have a look at it. So the fact that the delay notice was not given is a relevant factor in considering how much time you're going to give, but that's not an ultimate factor to refuse to grant an extension of time. So do not look at the contract from a quarrel model, or, oh no, the architect is unreasonable or the contractor is unreasonable. Look at the contract, look at the thing that asking for and what the contract says. In other words, read your contract. If you read it on the day one, perhaps there won't be an adjudication. Anyway, so that's defense in law. And then the question of fact, defense is a question of fact, meaning that although they say that there is a loss and expense, there isn't a sufficient evidence that the loss and expense was suffered. For example, you are talking about a global claim of loss of opportunity. You use the Emmerdale formula, the Hudson's formula, whatnot formula, 8%, 10%, this, that, the other, OHP. You just made a claim and you think, oh, I'm done. No, you're not done. This is a claim of loss of opportunity. So you've got to provide sufficient evidence. Walt's Lilly case, go to Aikenhead's judgment, his guidance, that you need to have contemporaneous or subsequently collated evidence that I had these opportunities during this period of time. I've refused it because I was stuck with your project. That's the first thing, loss of opportunity claim. And the profit bit, my overheads, my people were stuck with your project, then automatically what happens? You got to give them a discount for the variations you have earned, because you're not sitting for nothing. You earn some money there as well. And then the profit bit. If and unless you can show that you have earned less profit because you are held up, you don't have a claim. It's not a question of using a formula. It's a question, that's a legal bit. Yes, no problem. You have to show this. But with that, you've got to raise your question of fact and see if you are thin on evidence or not. And whenever it's a question of fact, it's a question of evidence. The legal burden of evidence is one, or he who asserts must prove, on balance must prove, okay? But there is an evidential burden. That's how to discharge it. That you've got to provide sufficient amount of evidence to convince the tribunal that what you are saying is factually correct. And the evidence has to be not inconsistent, or better said, if there is inconsistency, reconciliations are given through a witness statement that although these two looks are different, but it's not different, this is actually really talking about that, okay? That's the evidential thing. And many a times, you may not be able to create it. So the right time to create it is every meeting you go, you try to know the agenda, you know your contract, you know your duties, and you make it a point to talk from the contract. Many a times I say that a construction contract is something like a romantic stage that is entering into the contract, and the signing is the marriage. Then there's a honeymoon period. You get a front-loaded good money in first 1, 2, or 3 months, and then the variation starts. Then the delay occurs, and it starts like raising up a child, a very painful period, and it ends up in divorce after practical completion through the final account system or final application agreement, with the ancillary reliefs of delay damage or variation account conclusion, or sometimes some common law breach and remedy. So this is what on a daily basis, construction projects, they start and they end. Now, many a times at the period when you are getting married, or you are in the honeymoon period or early days, you tend to tell your professionals that this guy is making our life a hell. The employer is such a nice person. The contractor is such a nice person. Even the employer's wife becomes such a nice person. And then they say, forget about the contract. I've even seen in negotiations of contract meetings, they're saying we last 10 years, we have signed a contract and never looked at it, which is a blatant lie. You start looking at it after a few months, when the variation accounts start growing, when the delay starts. You always do. Now start doing it right at the day one and create your contemporaneous record, analyze your position from a contractual perspective. Well, you can't go back and do it if you have already done it earlier, but try to create or look at how to construct a consistent piece of evidence which supports your view. If you have considered something earlier, kept silent because you thought, okay, if I say this now, there's going to be a problem, all of a sudden now you cannot say so. Because why you were silent then, or why you have said something differently, will come into the show. So it's also important that you produce very consistent evidence. And if there are gaps, which is very common, give witness statements. As an adjudicator, we see that claims are thrown to us only on the body of the referral, the response. There are statements. There isn't even a statement, witness statement by the people of the company who's explaining the fact any further, let alone talking about some email correspondence and other things. It doesn't always have to be a correspondence. It could be real. Someone saying there is a defect, you come back and say, look, this is the picture. Or I invite the adjudicator to visit the site and see. We are all construction professionals. Very difficult to dodge us if you invite or if you give us photographic evidence that this is what has happened. So it doesn't always have to be. Take the challenge. So let's go and open it, have a test. Unless you have done something which you want to hide yourself, you will stand up and take that challenge. That let the adjudication be adjourned. If this is what it is, this type of test can tell us what the result is. Because some damp in the whole building doesn't mean that everything is wrong. If you are in construction, we know, okay? So that's how you consider it and try to discharge with sufficient evidence. I've come to the last of the slides today, is the rejoinder. Normally, if you're defending a claim, you get one chance for sure. That's a response. It's also very normal that you bring in certain things which were not in the referral for tactical reasons. So almost automatically, the responding party will ask for, the referring party will ask for a permission to allow them to submit a reply, and it's allowed. And then if there is a reply where there are things which you need to make about them, need to make a further submission, do ask for a rejoinder. Why do you need a rejoinder? Do an arithmetical calculation that these were the points in the referral, this is the evidence relied on, this is what I said into the response, so this is the residual dispute has come into the scenario through the reply. This point has not been stated earlier, or not referred to earlier, or can be explained under earlier evidence already submitted. That's the reason. Also for denial. If you have a piece of evidence which is not actually relevant, to be able to say that this is not actually relevant. How to seek a permission? A, very quickly. B, stating that I want to add some points regarding A, D, these 3 or 4 points. It doesn't matter if you, in the end, add some more. But just because the reply raises some points which has not been raised earlier, so I need a rejoinder and I need 7 days. This is not a good practice. Make it a real effort. Point out, why do you need a rejoinder? And what if the permission rejected? Doesn't matter. You can still send it through. And if the adjudicator doesn't take it into account, unless it's too late, you'll be in breach of natural justice. And then this is all about rejoinder. I have two more things to discuss. They do not merit a separate slide, so I've brought in onto this rejoinder thing. One is, even after the decision is issued, if you think the adjudicator has made a mistake, you can come up with a slip rule application to change it or to correct it. And we have a recent decision where it says that you can then, the adjudicator, go and even change his basis. And of course, after the decision has come, you can challenge it if you have material grounds to do so, either on the jurisdictional issue or on the substantive issue. And as I said many a times, I will have a full session on enforcing and challenging decisions, the adjudicator's decisions. So it's just a reminder for that day. And that's all I think for today. Any questions?
We do indeed have a question, Mohammed. Someone's asking, contract or condition may be express or implied. How differently would you approach express condition and implied condition given a situation that could have both?
Well, very simple. Express, forget about conditions, because let's not get into classification of terms debate. Let's say a term of the contract, right? Normally, a term in a construction contract, if there are a few recitals, some articles, some particulars or works information, whatever way you call it, and then some conditions written, whether they're conditions or not, they're terms of the contract, okay? And then terms incorporated into the contract through external documents, which are called the contract documents incorporated into the contract. So these are the areas, okay? If you are trying to find out what's your obligation, you go through a contract review on that point, taking all of these into consideration. If your argument is that page number such and such of this section of the contract I'm talking about says this, that's an express term. And you are pleading, you like to call it a condition, like to call it a warranty, whatever inanimate term, it's a term. And if it's written either onto the body of the contract itself, meaning the initial sections where the recitals and other things are written, then some articles, then some particulars or works information, and then you go to the condition section, then there are some optional clauses. These are all added together. And then, of course, the documents that are referred to within the contract as part of the contract. Also, anything written there is a term, and that's an express term because it's written into the contract document. And if you say that this particular term says that I'm entitled to a variation if I do something like this, or I'm entitled to a payment if I do something like this, or he's obligated to pay liquidated damages if the delay is certified by the architect, that's it. That's an express clause. That's an express term. That's an express condition if it's a condition, because not all terms are conditions in a contract. Implied one. For example, you are saying that the contractor did not perform the item of the works at right quality, okay? So the quality of the work is not as per the contract. It could be that it's part of the express terms of the contract. For example, you said PSEN 709 blah blah complied door handles, but the door handles in fact only complies BSEN 309. Straightway, a breach of the contract, the work is not as per the contract. It may not be a defect. There may not be any shrinkage, no problem whatsoever. But still, you guys have agreed expressly that the door locks or the door handle is going to be of this type, and it's a different type. Now you can at the same time say that under the Goods Services Supply of Goods and Services Act, it's an implied condition that if a particular thing is described, then that's a condition to the contract. That's the implied one. Because the High Court of England has said that in every construction contract, the Services of Goods and Supplies Act applies. So if the quality parameters stated in that statute is dictating something and the reality is something else, that's the breach of an implied term. Same about quality. One could be agreed under the contract, expressly written on it. The other, not written in the contract, the statutorily required thing. That answers the question.
Okay, thank you very much, Mohammed. That seems to be the only question we have this evening. So obviously, your level of detail has been perfect. Just to say thank you to everyone for attending, and thank you to you, Mohammed, for your time this evening. Our next seminar is next Wednesday morning, where we'll be talking about compensation events with Richard Silver. But until then, and obviously we next see Mohammed on the 8th of July with the next in the Adjudication Matter series, where he'll be talking about jurisdictional challenges. So that'll be an interesting one.
Also natural
As
justice,
always, if you'd like places on any of these, please don't. And natural justice, sorry, yes. As always, if you'd like places on any of these, please email me at seminars@silverllp.com and we will happily book you in. So thank you, everyone. Thank you, Mohammed. Everyone have a good evening, and we will see you all again soon.
Bye.
Bye.